Thank you so much. And it's also, of course, a huge delight for me to be able to have this conversation with you, Philippe. So thank you for coming. We could not possibly, in the span of the hour together, cover the range of your work. So I think we're going to focus today on genocide, crimes against humanity, self-determination, and maybe the future of the world order, if we can call it that. And so let's start with East-West Street and crimes against humanity and genocide. East-West Street, for those of you who have not read it, is a really magnificent book. It's a book about that really nicely traces the history of Philippe's own ancestry with the history of these two core crimes in international law, genocide and crimes against humanity. And the way it weaves together your own history with the history of this area of this body of international law is really just an artistic masterpiece. So congratulations on it. But I want to focus on genocide and crimes against humanity as two foundational crimes in international law that emerged together or have a shared history, overlap in application. In some application, genocide generally refers to an effort to destroy in whole or in part a national, religious, ethnic group, and crimes against humanity to the systemic or widespread destruction of a civilian population. And so tell us a little bit about how these two crimes sort of emerged together, but also did not quite emerge in the same form and took different paths from their origins to where they are today.
Sure. Well, first off, it's incredibly nice to be here at the Italian Academy. I've not been in the building before. I have a dear friend who's involved in the running of it, and the organization of this event has been absolutely wonderful. But what a building, what an amazing space. I had absolutely no idea, David. It's an astonishing place. And it's really wonderful to be here with you, Monica. Just before I get into that, just to say, life is full of the most curious connections. And it is true that I sit on the International Court of Arbitration for Sport, and that this summer I will probably have the single best gig I've ever had in my entire life, which is I am one of the 8 judges of the Court of Arbitration for Sport who is required to be at the Olympic Games to judge issues of corruption, cheating, trans issues, all sorts of things. But remarkably, I have been sitting on a case before the Court of Arbitration for Sport which raises questions of genocide and crimes against humanity because, almost unbelievably, the president of an African football federation, part of FIFA, was indicted by the International Criminal Court and is currently being tried before the International Criminal Court for crimes against humanity and genocide. And remarkably, although the investigations had at the Security Council had shown his involvement in these crimes and laid charges against him, for 5 years, FIFA did nothing. And that has given rise to a series of very interesting legal issues as to whether the president of a football association, who is alleged but not proven yet to have been involved in such crimes, is fit to serve as the president of a sporting association. So the world just takes these really strange directions. So I became involved in these issues of international criminality, as we were discussing before, really only when I was in my 30s, when I got involved in the drafting of the statute of the International Criminal Court in The Hague. And with my friend Andrew Clapham, we drafted the preamble to the statute of the International Criminal Court. I was particularly... Yes, it's still working. I was obviously particularly interested in that area because of my own family history, which I describe in East-West Street, which was a family history that passed sort of in silence at home, which was the obliteration of my grandfather and grandmother's family. They were Austrian, Jewish, and fled, and my grandfather was the only survivor from a family of 80 from the city of Lviv in Ukraine. And having got involved through the International Criminal Court and then been involved in cases before the International Court of Justice out of the context of Yugoslavia and in domestic proceedings out of the context of Rwanda. In 2010, I get this invitation to go to the university in the city of Lviv in Ukraine, which, very frankly, I've never heard of. Most people had never heard of the city of Lviv. I did a bit of checking, saw that Lviv was the same place as Lwów in Wales and Lemberg, not in Wales, Lwów in Poland, and Lemberg, part of the Austro-Hungarian Empire. And it clicked. My grandfather was born in the city of Lemberg. I hadn't realized it was the same place. So I think, yeah, I do want to go to Lviv. I do want to go and give a lecture there on the cases I do on crimes against humanity and genocide. And in the summer, as I'm preparing my lecture, I stumble across, and can take no credit, I didn't have a hunch, I didn't have a thesis, it was pure accident. The discovery that the man who put the concept of crimes against humanity into international law in the Nuremberg Statute in the summer of 1945, Hersch Lauterpacht, later professor of international law at Cambridge University, studied at the University of Lviv. And I thought, great, I'm going to turn up there and announce that it all started in Lviv on crimes against humanity. I thought that was great. And then I carried on, and, blow me over, the man who invented the concept of genocide, Raphael Lemkin, also studied at the University of Lviv, not at the same time as Lauterpacht. Sort of 3 or 4 years later, they didn't overlap. And all roads on crimes against humanity and genocide lead to the city of Lviv. And so I turn up in Lviv and announce, and they had no idea that the originators of these two crimes were students at their law faculty. We found the room where they studied, we found their student materials, and so on and so forth. And so a book that was essentially written as a homage to my grandfather, who I loved dearly, and who lived until 1997, but never talked to me about what had happened to his family, became a book that is now translated into more than 30 languages and is sold all over the world, which I had never expected, and has completely changed my life and changed the way I think about crimes against humanity and genocide, which we were talking a little bit about before.
And so tell us, how has it changed the way you think about these two crimes? I mean, because I've heard just a little bit of it, but...
So if you go out in the street and talk to people about crimes against humanity and genocide, you'll get two observations. The first is that they think these concepts have been around forever, since time immemorial. Most people don't appreciate they are inventions, very recent, just 75 years ago, and they were created by individuals who came up with these concepts, who shared the idea that international law, well, what they shared was the revolutionary notion that the power of the state is not absolute. The state is subject to limits in terms of what it can do. In simple terms, up until 1945, as a matter of international law, if a country said, oh, everyone on this side of the room will live, everyone on this side of the room will die tomorrow at 6 p.m., international law said, well, that's fine, you can do whatever they want, they're your citizens, you can treat them as you want. And so the revolutionary idea was to say, no, that's over. There are limits, not only in relation to your domestic law, but under international law. But Lauterpacht and Lemkin had a different conception of how to do it. Lauterpacht's thesis was, we create a system in which international law protects human beings because they are living, sentient, individual human beings. Every human being has minimum rights under international law, including the right to be protected. That's the Lauterpacht route. The Lemkin route is, well, that's all well and good, but actually, and it's what we're living through now, and we've lived through probably since time immemorial, people don't get targeted because of their individual actions or propensities or characteristics. They get targeted because they are a member of a particular group that is hated at a particular moment in time and place. And so if you want to protect the individual, actually you should protect the group. And that's genocide. And that's the struggle between crimes against humanity and genocide. Second thing that you will pick up, if you go outside and do a poll of people on the street, if you ask them about crimes against humanity, they'll sort of look at you like, what's that sort of technical legal term? And they're not much interested in it. But if you talk about genocide, they'll say, oh yes, we're totally against that, that's really terrible. And what has emerged in 75 years is a hierarchy in which genocide has emerged as the crime of crimes in the ideas of most
people. I'm not sure why that is. I'm not sure whether it's because there's something about the destruction of groups that touches us differently. I'm not sure whether it's the magic of the word invented from genus and side by Lemkin, but genocide is now seen as the ultimate horror. In my book, genocide is not worse than a crime against humanity or a war crime. If you kill 10,000 people, whether you put on it the label war crime, crimes against humanity, or genocide, in my book, they are all equally terrible. But if an American president says there's a war crime over there, it's not going to be reported. If an American president says there's a crime against humanity over there, it won't be reported. If an American president says that's genocide, it'll be on the front page of every newspaper in the world. And that is what's given rise to many of the difficulties we're now facing in our international legal order.
Well, so that's interesting. So I would like to hear a little bit more about why you think that's what's given rise to the difficulties in our international legal order. But before I ask that question, I wanted to just follow up on this tension that you drew between crimes against humanity and genocide, because I think the account you give of how people react to the two is exactly right. And it's reflected in some ways in formal international law, right? Like we have a genocide convention. It was adopted 1956 or something, is that right?
48.
Oh, 48 even, so very, very early. Crimes against humanity, we still don't have a treaty that actually establishes crimes against humanity as a separate and distinct crime, although it is incorporated into the Rome Statute for the International Criminal Court. So they, even as a matter of formal international law, they're sort of treated differently. But operationally, crimes against humanity have actually done so much more work in the world to hold people accountable for atrocities, right? Because most of the cases before the International Criminal Court have been decided on crimes against humanity grounds, partially because it's an easier crime to identify, and genocide has a higher bar. So I guess I wanted to ask whether first of all, why you don't think that hierarchy ought to be what it is, and second of all, whether despite the hierarchy, it's actually the case that crimes against humanity is doing most of the operational work in the world, and holding on to genocide in the way that we do sort of in some ways allows crimes against humanity to fill in the gap and to do a lot of work that needs to be done, but can't be done so long as we have this other crime out there that's such a high standard.
So just to explain this in context for those who are not steeped in daily life on crimes against humanity and genocide, if you're a prosecutor and you've got to prove these two concepts, what do you have to do? Bloke goes into a town and kills 1,500 people. That's generally going to be a crime against humanity. All you've got to prove is that the individual went in, had no lawful reason for killing such a large number of people, and did so indiscriminately as part of a widespread and systematic act of killing. That's all you have to do. You don't have to prove what was the intention of the perpetrator. Genocide, you've got to prove that the intention of the perpetrator was to destroy a group in whole or in part. That is relatively easy to prove if the perpetrator leaves around a piece of paper which says, I'm going to kill all these people in order to destroy the group of which they're a part. But after Nazi Germany, perpetrators sort of learned that it's not a very good idea to leave bits of paper around saying, I'm going to kill all these people. So the courts, the International Criminal Tribunals, the International Court of Justice, have developed a practice where proving intent is notoriously difficult. You know, why someone does what they do. And states don't have intentions, human beings have intentions. So you've got to get into someone's head and work out why they did what they did. And the courts have basically developed a standard, which is you infer intent by a pattern of behavior. And the courts have then gone even further, in my mind ridiculously further, by setting a standard which basically said, and this is what I faced in cases like Croatia versus Serbia, that to prove an intention to destroy a group in whole or in part, you would basically have to prove that it's the only intention to act. And in life, we know from our time with psychologists and psychoanalysts and so on and so forth, that no one has a solitary intention. You might want to be responding to a terror attack, or you might be acting in self-defense, and yeah, actually on the side, will kill and destroy this group, that's not genocide, because there are a multitude of different intentions, and the primary intention is not the destruction of a group in whole or in part. Now, the reason the courts have gone to that level is to stop the floodgates. They don't want to be deluged with cases. In Croatia versus Serbia, I argued before the court, and I lost completely. They swatted it away. You should lower the threshold back down to what its inventor, Raphael Lemkin, said, which is, you know, if you go in and it's plausible that the intention was to destroy these people because they were part of a group, that's genocide. He regularized genocide. He had thousands of examples in history of genocide. But in our times, it's become very narrow. And that leads to completely absurd situations. I'll give you one anecdote as an example. I served on an advisory committee in the United Kingdom on academic aspects of International Holocaust Memorial Day. And in the UK, International Holocaust Memorial Day marked not only the killing of Jews between 1933 and 1945 in Europe, but other terrible acts of mass atrocity. And so I rather innocently said, so how do you decide which ones you're going to choose to mark? And they said, oh, we have a formula. We've been helped by the Foreign Office. So the moment you hear words like that, you think, okay, you know, there's a certain history with the United Kingdom, and you can imagine the Foreign Office would want to sort of ratchet things down somewhat. And they said the formula is, A, it must have happened after 1945, and B, an international court must have characterized it as an act of genocide. I said, okay, let me just see if I've understood this correctly. That means you will mark the killing of 8,000 Bosnian Muslim men at Srebrenica, a genocide ruled by the Yugoslav tribunal, but you will pass in silence in the murder of 3 million people in the Congo between 1998 and 2003, because that was only called a crime against humanity. And they said, correct. So the moment you put it like that, you realize it's absurd. Why are we putting some people on a pedestal for honoring, marking, and then passing in silence on the rest? And of course, if you take the temporal limit of 1945, it has the happy consequence of excluding, for example, the Ottoman Empire's killing of up to probably 1 million Armenians, putting aside the question of how you characterize that act of killing. So what's happened is we've sort of created a league table of victimhood and horror, which I think is not a socially useful thing to have done, because it creates competition between groups. And if you ask any prosecutor at an international criminal court what the victims want, they'll all tell you they want it to be genocide. And anything less than genocide isn't good enough. And this creates a further problem, which I've observed in my own work. The need to prove the intention to destroy a group in whole or in part reinforces the sense of identity amongst the victim community with the victim group and with the perpetrator community as the perpetrator group. And so the concept of genocide actually has the consequence, and I've seen it in rooms with prime ministers and presidents, of reinforcing intergroup hatred, which has brought me to the place where I actually think, notwithstanding the excellent intentions of those, well, Raphael Lemkin, who was a remarkable person, who lived very close and died very close to this spot where we're sitting, and who I honor and love as a person, but he unleashed something which I fear has given rise to a greater propensity to do the very thing he wanted to stop, namely one group turning against another group. And that is the unintended consequence of the legal system we have put in place.
So this is not, I think, the conventional view, although it is a view that I happen to share, so unfortunately you won't get like a heated debate on that particular question up here. But I did want to ask the question of whether you think that's particular to genocide, or instead reflective of the sort of like accountability machine in international criminal law. So Some of the work, for example, on the former Yugoslavia suggests that the setting up of the tribunal, the International Criminal Tribunal for the former Yugoslavia, which was set up through a Security Council resolution in the 90s to deal with the atrocities that were committed in that region, that it then also had the effect of, because the conflicts there were, after all, interethnic conflicts, that it also had the effect of breeding these interethnic rivalries and therefore reinforcing group identities in ways that were really pernicious. And so is that a sort of dark side of the international criminal law project, that the process of trying to hold people accountable at such a high level of sort of global attention necessarily in situations in which you're sort of, as you say, necessarily involved in group conflict? That's what a war is. It's one group against another, highly organized group. Does that project itself have the usual consequence, the necessary consequence of sort of breeding intergroup hatred and therefore creating the conditions for the next conflict down the road, as opposed to what might be a sort of less accountability-driven, more conciliatory effort to try to move an entire society beyond it?
In short, yes, it is the dark side. It is the dark side of international criminal law. That's not a reason to get rid of it. It's a reason to think about how it functions. I am a passionate believer in accountability. I'm against impunity. All of my writing and all of my books have that as their beating heart, and that is driven from a personal family history. It's very simple. I think a lot of us are deeply informed by our own personal family histories, and that informs what we do. So I think there is a significant problem, but that is not a reason to tear down the entire structure. We have alternative ways of dealing with some of these issues. South Africa did it, for example, in relation to truth and reconciliation. Warts and all, and I'm not starry-eyed about truth and reconciliation. Nevertheless, it's another model. And Rwanda did exactly the same thing with its system of domestic courts, is not quite how one would call them, but they're gacaca bodies, which addressed community by community tales that had happened. Northern Ireland right now is struggling towards some system of truth-telling as a way of excluding the application of the legal order. I suppose what I'm saying is we need probably a system of rules at the national and international level and the criminalization of behavior as a sort of long stop. Sorry, that's a cricket term. That's probably not.
Yeah, I was like, I don't know what that is.
But don't for a single moment think that by creating this structure of international rules, you're going to deal with the problem. I mean, we've had domestic rules for centuries in relation to physical abuses, rape, other types of act. It hasn't stopped the behavior. So we need to think, I think, much more deeply. And the reason we need to think more deeply, taking your point, and I know you've done a lot of work on the Yugoslav context. So I was immersed for 15 years in the former Yugoslavia. One of the things that I did, I was counsel for Croatia in the case before the International Court of Justice. And I can tell you that in Croatia, at the highest levels and at the lowest levels, there is a sense of fury that the Bosnian Muslims got a confirmation of an act of genocide in relation to Srebrenica. But the Croats did not get genocide. They only got crimes against humanity and war crimes in relation to Vukovar and other acts and horrors. And I've seen for myself the sense of anger and fury directed towards Serbs and directed towards Bosnians, Muslims, because of that simple fact. And I suspect that over time, we will get to a situation where the failure of the ICTY to have delivered justice in a way that was acceptable to the different communities in the round will of itself give rise to new hatreds and new conflicts. And we have to face up to that problem. We can't just run away from it and say, oh, it's not really a problem, doesn't matter. We've got to address that problem. Now, how we address that issue, I think, is complex. But against that, arguing against myself, let's not forget that we are in the earliest days of elaborating this structure of international criminal justice. it was only created 75 years ago. There was nothing before that. And in the scheme of things, 75 years is nothing. When I was a young academic in the 80s, a research fellow at Cambridge University, I had a colleague who was a very famous and wonderful professor of English legal history, John Baker, Sir John Baker. Wonderful person. And as a young academic, he'd sometimes say, come on, let's have lunch. I want to hear what you're working on, Philippe. And I'd go and have lunch with him, and I'd tell him what I was doing, and he'd sort of look at me and he'd say, oh, yes. Yes, we had a similar problem in English law in 1468, and it took 275 years to sort it out. It's sort of a way of saying we're just at the beginning of a long game and a long story. Let's not self-flagellate too much. It's a work in progress. And with my students, that's how I deal with it. It's for the students in this group to be thinking through as you go forward. This is the system we've got. It's not perfect. It has unintended consequences, but actually it's a work in progress, and let's see how we can, as we go forward, make it better, looking on the bright side.
Okay. Well, I think that's a good transition to, as a work in progress, self-determination. And just sort of change course a little bit and focus maybe to situate it in your writing, The Last Colony, which is a book about the Chagosians, who are a people separated. The Chagos Archipelago is an archipelago that was separated from the state of Mauritius during the decolonization process, where the UK said, as I understand it, please correct me if I'm wrong, thank you very much. We will let you be your own state, Mauritius, but as a condition, essentially, of our granting you independence, we are going to carve out this part of your territory, the Chagos Archipelago. We are going to essentially lease it out to the United States, put a military base there, and most of you will have to evacuate, if not all of you. And you bring a case to the ICJ, and you say, this is a violation of the Chagosian right to self-determination. One of the conditions of decolonization was that the decolonization process was supposed to occur without the dismemberment of the territories at issue. That's not what happened here. This is like the paradigm case of what ought not happen during decolonization and the process of independence. And the ICJ agrees with you. And this is a huge victory, I would say, in many ways. And so I want to hear a little bit more, and I think the audience would like to hear a little bit more, about just the personal stories behind this, because I had the opportunity to watch a video that you did with some of the Chagosians, where you were sort of on a raft trying to get the UK to take more seriously this judgment against it. And you were sort of going back to the islands. And just the personal identification of the people to a particular plot of land and what it meant to them to get an ICJ judgment in their favor, that they actually had a right of belonging to this territory which they understood as theirs, despite having been evacuated from it decades earlier. And so could you talk a little bit more about the personal element?
So one thing to say about this book, The Last Colony, came out in Britain in 2022 in September, and in the States a year later. Interestingly, it came out in the States a year later because the central character in The Last Colony is a remarkable woman called Lisby Elise, born in 1953 on a tiny island called Peros Banhos, one of the 58 islands of the Chagos Archipelago, who in 1973 is forcibly deported by the British authorities and sent to Mauritius, and to make way for an American base, which many of you will have heard about Diego Garcia, even if you haven't heard of the Chagos Archipelago. I'll say more about that in a moment. And it was an interesting experience because this is a book which is probably best characterized as literary advocacy. We had a ruling from the International Court of Justice, an advisory opinion, that Britain's occupation of the Chagos Archipelago was illegal under international law. A ruling that was in effect unanimous. There was no dissent from any judge on the merits, although the American judge dissented on jurisdiction, which is different. And Britain basically stuck two fingers up at the decision. And I wanted to find a way to get more people in Britain thinking about this story. And the only way to do that was to write a book. And so I wrote a proposal. The
proposal went off to my various publishers, and they all said, yes, we'll publish it, except in the United States. It was very interesting. It coincided with the pinnacle of Black Lives Matter. And Alfred Knopf, in its wisdom, decided, and I didn't challenge it, I respected it, that was their decision, that you could not have a privileged, white, British guy writing a book in which the central character was a black woman descended from enslaved people who could not tell her own story because she can't read or write. And so they put it on hold. Eventually they decided to publish it, and that was fine. It was an issue I had already myself thought about a lot, because there is, in a sense, a recolonization of the story, having me tell Lisby Elise's story. Although when I told Lisby it wasn't going to be published in America, she sort of laughed and said, that's ridiculous, I can't write, so who's going to tell my story? That's another matter. But it is a complex issue, and it does require thinking about. So to wind back a little bit on the personal aspect of it, it actually started for me in the very same month that East-West Street started. April 2010 was the month that I received the invitation to go to Lviv. It was also, in the first week, the month that I went on skiing holiday with my brother, was sitting on a chairlift, and my phone rang, and I'm always very nervous on a chairlift with my telephone because I'm really scared of dropping it and sort of losing it down there. But I sort of got it out of my pocket with my gloves, and it was, I didn't recognize the number, +230, and that got me all sort of curious, like, where's +230? So I sort of had to answer it, and I'm on the chairlift, and it's the person at the other end says, this is the office of the Prime Minister of Mauritius. The Prime Minister would like to speak to you now. And in our world, as you know, some calls you can say, can I call you back or whatever, but those are not the kind of calls you can really say, I'll call you back. So you take the call, and the Prime Minister's on the phone, and he starts talking about this place called Chagos. I've never heard of it. I'm 50 years old. I've never heard of the Chagos Archipelago. And he's a smart guy, and he works out pretty quickly that I've never heard about it. And he says Diego Garcia. And of course, Diego Garcia I had heard about. I knew about the American base at Diego Garcia because it's the base from which the bombing of Iraq began in 2003. So in relation to the book Lawless World, my view has always been the war in Iraq was unlawful. The bombing from Diego Garcia was unlawful. I knew about Diego Garcia. But after I agreed to take on the case, which was design a legal strategy, I sort of asked myself the question, how could it be that I've never heard about the Chagos Archipelago? How could I be that I've never heard that 2,000 people were forcibly deported by the United Kingdom government in my lifetime? I thought this, how could it be that a new colony was created in 1965? I thought that was the whole point of the UN. Colonization was over, the creation of colonies was over. And so I went back to my school history book. I describe it in The Last Colony, and it was really shocking. It explained a lot about my generation in the United Kingdom, but not just the United Kingdom. I think probably most European countries. I mean, Italy too, frankly, in relation to Africa. That became very relevant. I mustn't forget to mention the role of Italy in all of this, since we were at the Italian Academy. But I went back to my school history book, Geoffrey Treece, This Is Your Century, which we read as 12-year-old kids. And chapter 8, I think it was, maybe another chapter, was called Sunset on Empire. And it began with a comparison between two men. The first man was Lord Mountbatten, the last governor of India, described in our school textbook as a magnificent specimen of humanity in all ways, particularly as compared to his successor, a short, thin, vegetarian, pacifist fellow, and I apologize for what I'm about to say, but it's in our school book, who looks a bit like a monkey wearing glasses. Mahatma Gandhi. Okay? That's what we learned. That's what we learned at school. So that was a real shock. And it sort of explains why people like me and my generation just never really focused on these issues, because we'd sort of ingested this kind of material. I felt ashamed, actually. And it sort of redoubled my desire to really get involved in this case. And to a certain extent, this case has radicalized me more than any case that I've done, because I came to know the community. Many of them are still alive. They're very decent folk. They are angry, but they're not bitterly angry. They just want to go back. And working with the government of Mauritius and that community, we designed a legal strategy. It started very early. I mean, it was very tough. Mauritius is an African country with a population of about 1 million people, and it's taking on 2 permanent members of the Security Council. And there's the largest American military base sort of outside the United States. So it's not immediately apparent that our prospects of success were very high. And I remember going very early, I describe it in the book, we went to the State Department, where we were mates with the people who were there. The legal advisor at the time was maybe your professor or colleague.
No, but yeah.
Harold Coe, wonderful person. And we went to see him. Hillary Clinton was the Secretary of State. And Harold met us with 7 or 8 legal advisors, and we told him that, yes, we were going to start a case against the United Kingdom, but this was not hostile against America, and we weren't aiming at the base would be able to continue. And he sort of looked at us and just said, it's a totally hopeless argument, and it won't even get off the ground. And of course, 10 years later, we've had 3 judgments and decisions of international courts and tribunals ruling the United Kingdom's occupation is illegal, and the UK and Mauritius are in negotiations to resolve the matter on the basis of international law. And I give the UK real credit for changing position and giving effect to its commitment to the rule of law. That's not necessarily an easy thing to do. Now, the last colony was published in September 2022. The UK change of position took place in November 2022. So I would really love to be able to say to you, the last colony changed the British position, but I don't think that's what happened, because there was another intervening event. And this is a sort of segue into the world we are in today, which is a lot more complicated. And it became clear to me in the summer of 2022, when I was in The Hague and I attended a private dinner at a European ambassador's home with 10 other ambassadors, all Europeans, except for a Mexican ambassador and the South African ambassador. And the British deputy ambassador was there. And so I, out of an excess of British politeness, of course, the last thing I was going to do was talk about Chagos, don't raise Chagos, don't mention the war, blah, blah, blah. So I didn't raise it. And then at a certain point in the conversation, by now, Ukraine had been invaded by Russia. And this was a big issue. But as you know, the response to that war has essentially been a European response. And the European countries in the United States and Australia are having trouble getting countries from the global south, as it is sometimes still called, to engage with that conflict. And the South African ambassador then took the floor and said, so interesting, this Ukraine-Russia thing. He said, yes, just the other day, we had the British come to us and seek our assistance to remove Russia from its illegal occupation of Ukraine. And so we said to them, let's just see if we've understood this correctly. You would like us to help you remove Russia from its illegal occupation of Ukraine whilst you continue to dishonor a decision of the International Court of Justice ordering you to stop your illegal occupation of Africa. We don't think so. Fuck off. Literally. And so we're living now in a world where these things are interconnected. And of course, the world of double standards is rife. It's everywhere. No one has a monopoly on double standards. Russia bombs the shit out of civilians, killing thousands of civilians, including my friend, the writer Victoria Amelina, but all of a sudden discovers the need to protect civilians in Gaza. South Africa brings a case against Israel alleging genocide, and at the same time welcomes Mr. Lavrov to visit South Africa with open arms. The United States complains bitterly, along with the United Kingdom, about the bombing of energy and electricity infrastructure in Ukraine, but passes in silence when Israel turns the electricity off in relation to Gaza. So we're living in a world in which the complexities and the double standards are really coming home to roost across the board, and that's giving rise to a real sense of complexity. What's interesting is that at the heart of a lot of these double standards and a lot of the issues that are being articulated internationally, the rules of international law and the decisions of international courts, in a curious way, are moving, if not to center stage, to a stage as part of the process. And that, I think, is interesting.
So there are two directions I want to take this. And so I guess I'm going to start with the conceptual one, and then we'll get to this question of like the complexity of the world. And the conceptual one is just to continue the story about self-determination and to talk about it in the context of the Israel-Palestine situation and yet another proceeding before the International Court of Justice in which you spoke on behalf of Palestine. And the question presented was what consequences follow from Israel's continued occupation and annexation of the Palestinian territories. And one of the reasons two of the reasons that these two cases are related, the Chagosian case and the Palestinian case, is that both of them put directly at issue questions of self-determination, but both of them also, and this in a certain way ties it to Ukraine, put at issue claims to territory. I think in sort of cosmopolitan centers like New York, we don't appreciate the extent to which people around the world have deep connections to territory and view territory as part of who they are and are willing to fight and fight hard for territory. And we are seeing, in my view, an increase in territorial conflicts around the world. And this strikes me as an incredibly dangerous development. So the second part of the question will then be about the complexity of the world and the nature of the conflicts that we're seeing play out. But before we get to that question, let's focus still on this sort of self-determination trajectory. And so tell us a little bit about how you came to take on the Palestinian case and what the issues there were, and the proceedings were quite recent, so how those went.
Sure. So these are obviously very delicate matters, and as Monica said, and it's really important, on a lot of these cases that I'm talking about, I'm counsel, I'm involved, that means I'm not an independent observer, and you should therefore take anything that I say with a pinch of salt. In the classroom, of course, I make that very clear, but in the privacy of a classroom, you can talk much more openly about some of these issues. So in the Chagos case, we understood, when you're designing a case, and one of the reasons I wrote the last column as I did is I wanted my students, I wanted general readers, but I wanted also my law students to understand the real world of international law, not what it's like in the textbooks, which bears no relationship to how international law works in practice. It is totally disconnected. How you go about strategizing a case. And it's not strategized by a state, it's strategized by an individual. This is one of the themes all the way through all of my writing, is this idea that the world is governed by states, blah, blah, blah. Sure, it is in a formal sense, but behind the state, there are individuals. Why did the Gambia bring a case against Myanmar in relation to the Rohingya? Because, by total coincidence, the Attorney General of the Gambia, who went on a tour of Cox's Bazar after the refugees came from Rohingya, happened to have taken a course on international criminal law at the University of London and then gone to serve as a prosecutor at the Rwanda tribunal. And as he heard the stories of the Rohingya, in his mind, as he describes it, a remarkable person, he said, I know a genocide when I hear about one. And he persuaded his government to bring the case. And that's always how it works. So in the Chagos case, we knew that in order to persuade 15 judges of the International Court of Justice to be with us, we would have to do a number of things. And amongst those things, one of them was to take the military base out of the story. Because we knew, and the government of Mauritius knew, that if you're asking 15 judges to close down a US military base at Diego Garcia, your prospects of success diminish very substantially. The government of Mauritius understood that, and so from day one, made clear its position: the base, Diego Garcia, continues, except under Mauritian sovereignty. So that neutralized that issue completely. The second issue was we had to tell the court, because we have friends on the court, we know they're really a bit anxious about floodgates. Yikes, if we give effect to this case, we're going to be deluged with all these other cases. So we knew, and I really want to credit my late great friend James Crawford, with whom I did probably about 30 cases before the International Court of Justice. The way of understanding that when you litigate a case, you've got to get in the minds of the individual judges. Each is autonomous, individual, different, comes with their own baggage, their own ideology, their own ideas, their own interpretations, their own nationality. And so a lot of time is put into, if you like, gaming the court and understanding the backgrounds of these excellent individual judges. And we knew that the only way we'd get the case across the line is if we persuaded them there was no other case like it. It's totally unique. There is no other case in which, at the moment of decolonization and the grant of independence, the colonial power chops off a bit of the country and decides to keep it. Actually, there sort of is Comoros and Mayotte, but that is slightly distinguishable. And for the French judge, we constructed a little argument to help him get around that, and he did get around it. But basically we said, no other case, no precedent, no floodgates. But of course we knew that going with the argument of self-determination, which is the right of a community to decide for itself on its future direction and well-being, and implicit in that the principle of territorial integrity, that it is for a community to decide for itself how its territory will be run. And that is reflected in a 1960 resolution of the General Assembly of the United Nations, which frankly changed the world, Resolution 1514. It's a hugely significant document. It was the reason Mauritius won the case. That was the argument that we made. But of course, in our heart of hearts, we did sort of know that once the court has really opened the self-determination argument and the territorial integrity argument, others will come along. And of course, the next ones to come along were the Palestinians. And they basically hired the same team who did the Chagos case. And for me personally, of course, there was a period of reflection. I'm Jewish, happily Jewish. I believe Israel has a right to exist in safe boundaries. I believe Israel has the right to exist without being attacked by rockets and other things. But I also believe that Israel must exist in accordance with international law. And I had long come to the view that what was happening in the occupied territories, the West Bank, East Jerusalem, was rather manifestly in violation of international law. It could not be justified as a security act. It did not appear to be a temporary measure. There were 700,000 settlers who are told they will be there forever. That doesn't look to me like a temporary measure. I did what I often do on cases that are sensitive and rang around people I trust from a range of views to get a sense of the feel. And what came back very, very clearly was this is a real issue. And in fact, the person who touched me the most as I rang around was a very dear friend in Israel who lives in Tel Aviv, who is a writer, a very well-known writer. And I explained to her that I'd been approached, and I would take my own decision, of course, but I was just curious as to what she thought. And she said, look, I've got 3 kids. They're 10, 8, and 6 months. And frankly, anything that you or anyone else can do to make it less likely that they will have to serve in an army in a future conflict, I support that. The idea of
of the law being an alternative way of going forward. And so the upshot was I already didn't have any problem taking on the case. And we took on the case, and I was given the bit on self-determination. And so the bit that you're referring to was standing up before the International Court of Justice. What I can tell you from that experience is, I mean, I've done dozens of cases before the International Court of Justice. I've never done a case in which the judges were more attentive during the presentation of the totality of the arguments. Nor have I done a case which is so lopsided in the participation of the world. Basically, I think 52 countries and 3 international organizations participated. And left on their own were the United States, the United Kingdom, and Fiji, basically arguing to the court, don't answer the question. And, you know, I love Britain. It's my home. It's a great country which has done many wonderful things, as many not so wonderful things. But to listen to the arguments of the United Kingdom, I have to say was personally very dispiriting, because it's clear which way this is going. The court will give a very far-reaching opinion. I would be very surprised if the court does not say that the occupation by Israel of the West Bank and East Jerusalem is illegal. And that's very significant. Not that Israel will comply with the decision, but it's significant because it will be the first time that an international court has said that. And I actually believe separately here, speaking as an individual and as an academic, not as counsel for Palestine, that that's a socially useful thing to do because it makes a two-state solution more likely, not less likely. And that's a positive and useful thing to do because it delegitimizes the current situation. And so the processes that you go through in thinking about these issues are complex at a personal level, and one does think about them very carefully. I have to say, I sort of expected to get it in the neck from all over the world. And one of the things that's really surprised me, and I think it signals that something is changing very significantly, nothing. No criticism, no objection, no attacks, no social media sort of explosion of, you know, self-hating Jew, anti-Semite, anti-Israeli, whatever. Nothing of that kind. And that signals to me that something possibly is changing. But in any event, I just did a long interview for Die Zeit in Germany. One of the great things about the UK that I love, it's very rare as a country like this, is that if you, as an English barrister, do a case against the UK, that they don't mind at all. That's just part of your professional function. It doesn't make you anti-British. I still have my mates in the Foreign Office and the legal advisors and the Attorney General. And there aren't many countries like that. And so instilled in our being as English barristers is this sense that to act against your own country is not anti your country. It's just part of your professional activity. And similarly, you know, as a Jewish bloke, to act against Israel is not anti-Israeli, and it's not anti-Semitic. It's just in service to the idea, maybe it's naive, of the rule of law. And that's, I think, a socially useful thing to do.
Well, I'm cognizant of the time. I mean, that's such a nice note on which to end, although I do want to ask one more question. And I would say, by the way, the same is true of in the U.S. legal profession. I would say, I might even say it a bit more strongly, which is that to you bring a case against your own government or against an entity about which you feel some affiliation, maybe you in Israel, is in some the greatest sense of patriotism. In a sense, you're trying to improve that country's behavior. You're trying to change the situation.
But it's tough. You remember when the former legal advisor, Abe Sofair, was going to act for the United States against Libya, it became a front-page news story, and he withdrew. I mentioned to you before another case in which a very prominent and wonderful U.S. international lawyer withdrew from a case because of pressure of that kind. And I'm also a French national, and I argued against France in the mid-1990s on nuclear testing. I was telling you about it before. And to this day, I'm on a list
in the Quai d'Orsay of unacceptables. Un Français ne plaide jamais contre son propre pays. A Frenchman never argues against his own country before the International Court of Justice. So I think the Brits are really pretty unique in that aspect.
I mean, I don't know, but I would say that's probably right as a matter of government policy, but just in terms of civic duty, it's something I think that lawyers ought to take to heart. So I guess my last question, if we have the time, is, I'm looking to make sure we do, is, because we have sort of hinted at it a couple times over the course of this conversation, and I think we would be remiss if we didn't talk about it, which is the world we live in right now. And so you mentioned the great deal of the sense of hypocrisy. We've talked a lot about, I mentioned the problem of territorial conflicts becoming newly emergent. And I think lots of my students, lots of younger folks are, by which I mean just like younger than I am, and my generation, I think people across the age spectrum are quite worried about the future of the world. And so one thing that you might say is like, look, we're in this moment of transition. The international criminal justice process, for example, is not that old. It's only 75 years old. We're moving forward. The arc of justice is in a particular direction, and we're moving forward. And another worry, or another possibility, is when principle no longer becomes sustainable, when no side is able to actually stand for a position across the board because of the broader constellation of geopolitical and other factors at play in any given case. And as you said, every single one of these cases is related. What's happening in Ukraine is related to what's happening in Israel, Gaza, which is related to what's happening in the South China Sea, which is related to what's happening at the border between India and China, right? These cases don't happen in isolation. Everyone's paying attention to what everyone else is doing. And so, what's happening in Yemen. So one worry is that when these are the dynamics at play, the principles just no longer do any work. And yes, there is this like effort to rely on them and to bring them to bear, but if all that is happening is, and this is not, or if most of what is happening is that a side uses them only for its own purposes and disregards them in relation to the adversary, which is now stark and entrenched, then the principle just sort of falls out of the equation at a given point. And so that's a world in which law takes a real back seat and begins to regress. And how do you think about that? How do you think about how that can be avoided?
That's a wonderful question, Monica, and all of your questions have been very thought-provoking. I think about this a lot. We haven't had time to touch on what I think is the greatest challenge of all, and which is going to make what's going on with, whether it's Ukraine or Israel, Palestine, and South and Sudan and Yemen, it's just going to make it pale into nothingness, and that is climate change. I mean, if you really want to worry about what's happening, climate change is just going to make all of this just seem like, kids' games. I followed climate change from day one. I was in Geneva in 1990 at the Second World Climate Conference when Margaret Thatcher addressed the conference. She had a scientific background as a chemist. She understood what was happening. She gave a remarkable speech. I've never forgotten that speech. I'm not a Tory. I'm not very partial to Margaret Thatcher generally, but I remember what she said that day. I was in the room, and I negotiated the Framework Convention on Climate Change for a group of small island states, and we knew then what was coming, and we have now, I think, arrived at the moment where it is probably too late to do anything meaningful to prevent a catastrophe of enormous proportions that will lead to dislocations of human beings on a scale that is simply unimaginable compared to what has come, and in which the law will have to play a role. So a couple of things. I completely share the sentiment I think you're articulating. This is a really worrisome time. Really, really worrisome. Just to give one tiny example, it's not really about international law, but it is about law in an indirect way. Those of you who've read East-West Street will know there are four characters. There's my grandfather, Leon. There's Hersch Lauterpacht, the inventor of crimes against humanity. Raphael Lemkin, the inventor of genocide as a concept. And then there's a fourth guy
Hans Frank. Who was Hans Frank? Hans Frank was Adolf Hitler's personal lawyer from 1928 to 1933. And he was responsible for all of the cases that Hitler and the National Socialists got into difficulty with in that period. And in the book, I think I included a photograph of Frank standing with Hitler outside a courtroom in which Hitler had just received, lashings and eviscerations and all sorts of other horrors. And I've come to know Hans Frank's son, Nicholas, very well. He knows his father's work better than everything. And I've had conversations with Nicholas, even in recent weeks, comparing that moment in the German history and what happened in the courtrooms as the judges tried to hold this man to account. And this man then used the courts to further his political agenda. You can hear exactly what it is that I'm saying, because I think an analogous thing is happening here in the United States. And if you dig in to the history of the criminal and civil litigation against Adolf Hitler in Germany in the period 1928 to 1932, you will see that it was all to no avail. They all thought, oh, well, we'll hold him to account, we'll do this, we'll do that, whatever. And he turned it around in a different way. And I think before our own eyes, we are now seeing exactly the same thing happening in the United States. The more cases that are brought, the more he turns things around to his advantage. We've seen it before, and that worries the hell out of me in terms of where this is going in this country. Because warts and all, double standards and all, if the United States steps back from the kind of role that it has played in giving us the 1945 system, individual rights and to a certain extent group rights, I think the world will be a less decent place, and I worry a lot about that. What is the place of international law in all of this? It's a really complex moment. There's it's an irony and a paradox that as the world becomes more complex and more dangerous, recourse to the law increases. It's sort of really interesting. There's a sort of curious inconsistency. Never in my lifetime have there been more interesting cases before the international courts. And to give a single moment, in a sense, that reinforces why I think, international law is not going to sort out our problems. I'm not starry-eyed about international law. But it offers something. And that moment took place in December 2019 in the courtroom at the International Court of Justice. I was counsel for the Gambia against Myanmar in a case alleging genocide in relation to the Muslim population known as the Rohingya in Myanmar. A few days before going to The Hague, I'd been in Washington, D.C., and I'd been on a panel with a wonderful person who's sadly no longer with us, Tom Bergenthal, who I'm sure you will know very, really one of the most remarkable people. What you need to know about Tom Bergenthal is just two things. In 1943, he was in Auschwitz in the charge of a man called Joseph Mengele. By the late 1990s, he was the American judge at the International Court of Justice. Truly remarkable person. And he said to me, Philippe, can you imagine if in 1943 there had been something called a Convention on the Prevention and Punishment of Genocide, and there had been an international court, and there had been a country far away from Germany that heard about what was being done to me and other children and other people at this place called Auschwitz, and had gone to that court and said, they can't do that to those people. It would have given us hope. Then we went to The Hague a few weeks later and we argued, and I sat this distance from Aung San Suu Kyi. She was leading the delegation of Myanmar, Nobel Prize winner. She was doing it basically to defend the work of her father, who had created the Tatmadaw, the military that prevails today in Myanmar. And I did not like pretty much everything that Aung San Suu Kyi said. But she said one thing that really resonated. She said, Mr. President, members of the court, there may be differences between our two sides in this case, but at this moment, the only thing we all on this planet have in common is the language of international law. It is the only way that each of us can communicate in a form that we all understand. And in that moment, I sort of had an epiphany that, I'm not, you've heard, I'm reasonable about the prospects of international law, but it was a really interesting observation. And it is the case that if you go through all of these conflicts, there will be competing arguments about what international law means, blah, 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 this and that. But there's always a conversation about what international law allows or does not allow. And once you enter that conversation, you are, as a country and as a leader, putting yourself in a space which basically says you are subjecting yourself to a discourse on the language of international law. And that, I think, is a hopeful thing. However terrible these conflicts, whether it's Ukraine and Russia, Israel and Palestine, Sudan, Syria, lots of other horrors that are taking place all over the world, on all sides of the conflict, the proponents on either side always invoke the language of international law. And that, I think, is an indication of a possible way forward, without imagining for a single moment that some international judgment or the recourse to international law is of itself immediately going to stop the horrors. But at least it provides a means to converse and to exchange in a shared language, and that is a useful thing.
Okay, well, I think that's a wonderful place to stop. So please join me in thanking Philippe for being here. It's been such a delight to have you.
Thank you. Thank you.
It's good.
Questions from the audience or not? Do we have any questions from the audience or not? Yeah, it would be great to have some questions from the audience. Abigail, do we have time for a few questions from the audience? Great. Yeah, great.
Hold on, I was a little remiss because I thought I had run over time, but it turns out we do have a little bit of time. So why don't we take three questions from the audience? Of course, if you are not able to stay, feel free to leave, because I was so engrossed in our conversation, I let our conversation go a little bit long. And so why don't we start, there's someone way in the back right there with a hand up.
Let's take 3 or 4 questions together.
Yeah, we'll take 3 together, let's say 4 together, and then just answer them. So please, go ahead.
Hi.
Identify your name, please. And
I can't see where the question... Oh, yes, okay, yeah.
Yes. Hi, my name's Kia. I'm a senior at Barnard. So my question is, basically we've talked about, I guess, how the language of genocide and crimes against humanity has sort of originated in the global north. And how international criminal law has sort of, the framework for it has originated in the global north. I'm wondering if conversations like the one we've had today, if the tenor or the character of them differs at all among maybe your friends, colleagues, academics in the global south.
yeah, please, in the front row here.
I got it.
We'll have a microphone coming around.
Thank you. My name is Kate. I'm a journalism student at the journalism school here. I've got a question regarding the tribunal on Russia's war in Ukraine. You recently gave an interview to The Guardian where you said that the International Criminal Court and several judges on the court and Karim Khan were you blame them basically for their deadlock on the behind-the-scene developments on the setup of the new tribunal. So what is your take? Has there been any progress on that? And what do you think what kind of pressure is then necessary from the international community to get out of the deadlock? Thank you.
Okay, great. And right here and then all the way in the back.
you may have known my husband on the sports thing, the sports with the international, Gary Wadler, sports and doping, stuff like that. This is my question. Aung San Suu Kyi was under house arrest for years and years. How does she justify the woman she was then with the woman she became when it came to the Rohingya?
That's a good question. And then there's someone on the sort of on the side there, right by the drapery.
Hi.
You have a hand up. Oh no, is there I guess you
Okay.
put your hand down. Okay, go ahead.
Yeah. Hi, my name is Luma. I'm a Master's of Bioethics student at Columbia. At a talk at Vanderbilt University in November, you said that the, quote, conflict between Israel and Hamas is not a conflict between Israel and Palestine, and Israel is entitled to exercise self-defense. Putting aside the fact that, according to international law, Israel does not have a right to self-defense in territories that it belligerently occupies, such as Gaza, could you address how the destruction of civilian infrastructure, the bombing and attacking of universities, hospitals, schools, ambulances, refugee camps, and homes are acts of self-defense? Could you please address this quote? Thank you.
Great.
Great. Thank you for all these really excellent questions. I'll just try and deal with them in the order. I mean, it's plainly the case that the invention of these concepts, crimes against humanity and genocide, began at a particular moment in history in the context of a war in Europe, and the inventors, the proponents, came from a particular cultural background, Poland, Jewish, European. But I think we've seen over the years a very significant change. And one of the things that is most striking is if you look at what's happening at places like the International Court of Justice, you'll have noted that it is the Gambia that filed a case against Myanmar, an African country. It is South Africa that brought a case against Israel. Those are two cases filed under the Genocide Convention. And the context and I think it's too early to understand exactly what's happening, but it does cause us to think, is that for many, many years, the sense was that the system of international law was created, if you like, by the North to maintain a new form of neo-colonial power. But it's plain that something is happening that is changing that. We talked about the Chagos case. Mauritius goes to the International Court of Justice and brings a case against the United Kingdom, and the court finds unanimously, in effect, for Mauritius, a small African country, and holds the United Kingdom to account. That's pretty significant. And in the context of that case, I mentioned earlier, Italy had a certain role. At a certain moment, I asked Liz Bielizé, who came to The Hague and went to the court, how did she feel being in the International Court of Justice? I mean, she comes from this tiny island, then she goes to Mauritius, and now she comes to the World Court in The Hague, and she's center stage. And she said to me, I felt good. And I said, what was it that made you feel good? And she said, I was very surprised by something. What were you surprised by? I was surprised by the fact that the man who was in charge of the entire case, the president of the court, was black and he was from Africa. And it reassured her. She said she had not expected that. In her conception, people from other communities than her own, her origins are African, controlled things. After the case was over, I know the wonderful president, he was the president then, he's not the president now, Abdullahi Yusuf, from Somalia. We talked very informally about the case. You know, the English rules of professional conduct, you just don't talk about cases with judges before or after. But we had a little exchange about it. And at one point, he just said to me, you know, Philippe, you have to understand and remember, I'm from Somalia. When I was 7 years old, I had to sing Italian songs and dance under an Italian flag. I know what Liz Bielizé went through. And she had described feeling safe in his courtroom. And I think that, and also the cases currently before the International Court of Justice, indicate that there is a change taking place. The sense of ownership of these rules vested in one particular community is not the case anymore. Something is happening. Now, against that, it brings me, in a sense...
Are you going to move on
Yes,
to the
no,
next
please,
question?
yes, but I was going to, but please.
Okay, if I might just say
Yeah.
one thing in response to this question as well, because I think it really, I agree with everything that you say, Philippe, although I think the question really puts a finger on a serious issue, despite everything that Philippe says, which is that many of the centers for higher learning on international law continue to be in the what is referred to as the global north. And so one of the things that I think is so wonderful about the current moment is that there's sort of new energy outside of the global north for the project of international law. And one of the things about international law, as Philippe mentioned, is that it is a language that is available to everyone. It's not, these concepts are not static, like law moves over time, and the people who use it, this is a line in Philippe's work, you know, a trajectory, part of the project, I think. The people who actually use it and access it and speak the language are the people who get to shape it over time. And so it's really important that, you know, we have at these institutions people from those countries who can come and take and learn about the enterprise, but also that they go back to those countries, that they develop ways of accessing international legal materials, the international legal discourse, and sort of making it their own and making it over time. And so I think we're seeing that happen, but I think we are so far from where we need to be to make it a fully egalitarian, equal access project. And by the way, I would say it needs to go even beyond the question of just like from states of the global north to states of the global south. It would be much better, even in this country, in my view, if we could actually we had a legal culture where we as individuals could ourselves access international law and use it in relation to our own government. But because of the nature of our legal system domestically, that has very much been closed off to us. And so you might see this happening even in real world. Like, we don't really have, as individual citizens, that many legal mechanisms for trying to push the U.S. government, as big of a ship as it is, to change its practices internationally, because international law has very much been closed off to us in our legal culture here. So it's a project of, you know, the emancipatory project of international law is really an emancipatory project of getting it into as many hands as possible so that as many people as possible can use it to shape its future. And I think we're moving in that direction, and it's great that we've moved as far as we are, but there's still so much work to be done.
Well, we're on exactly the same page, because what I was going to do in answering the second question about the ICC was, in a sense, to undermine what I've just said and to reinforce Monica's position. I mean, one of the things my students are very clear about is I love being challenged and criticized and told that I'm wrong, and I generally think about things, and if I'm wrong, I'm wrong. But Monica's exactly right. And what I was going to say in relation to the International Criminal Court and in relation to this question of the role of what's called the South in international legal orders, Abdulaki Yusuf came to my university, University College London, a few years ago, and he talked about another field of international law, investor-state arbitration, where a private corporation brings a case against a state alleging expropriation or unfair, inequitable treatment or so forth. And one of the statistics he gave was 27% of the cases brought under bilateral investment treaties to the World Bank's Center for Investment Disputes involve African countries. And yet, of the arbitrators appointed, only 2% are African. And that indicates the scale of the challenge that still lies ahead. The same thing exists in relation to the International Criminal Court. Until very, very recently, if you went onto the statute of the International Criminal Court created in 1998, for more than 20 years, the only people who had been indicted, if you went on the website and looked at the list of indicted people, every single one of them was black and from Africa. Black people from Africa do not have a monopoly on international crime, so something has gone very wrong. And against that context, along comes Ukraine, which, aside from anything else, provides, if one's not being too cynical about it, the International Criminal Court with a fantastic opportunity to indict some white people, which, of course, is what it has done. I think, talk about it on another occasion, not so wisely, I have to say. It is the case that, it is interesting that everything you say gets picked up these days. I have said publicly that the International Criminal Court, or individuals associated with the International Criminal Court, have played a role in seeking to prevent the creation of a special criminal tribunal for the crime of aggression in relation to the manifestly illegal invasion of Ukraine by Russia. And that is essentially about turf. It's not about principle. They don't want a competitor institution created that could somehow take the glory away from the International Criminal Court. And I deeply regret that that kind of instinct is allowed to dominate. I know personally and for fact that some of the judges believe that and speak about that. I know personally and directly that that is the position of the current prosecutor of the International Criminal Court. And to my mind, the idea that you're going to stymie what I think is a useful potential development in the name of protecting your own institution is very frankly outrageous and leaves me very, very uncomfortable. There's always the question of what you say when you go public, being courteous, being respectful, but I'm very, very unhappy about the direction taken by the International Criminal Court generally, but including in relation to that issue. On the question about Aung San Suu Kyi, I mean, it is true that I have spent some time in analysis and with psychologists and psychiatrists, but I think I'm probably not the best placed person to explain quite why Aung San Suu Kyi has adopted the position she has. What I can say is this: sitting in close proximity to her and watching her and listening to her arguments and having very minor interactions with her, and based on the writing of The Rat Line, which is essentially about a son's love of his father taken to an absurd degree, what I observed, for whatever it's worth, was a daughter seeking to protect the legacy of her father. The Tatmadaw was created by her father shortly before he died and shortly before Myanmar, Burma, obtained independence. And I observed a daughter seeking to protect the legacy of her father in a moment in which the Tatmadaw was being hauled before an international court. That was what I understood to be happening. It's, I'm sure, not a complete explanation, but it resonated for me with my broader thesis that to understand why people act as they do, it's not ever sufficient to look only at the publicly stated reasons, and you've got to look at the individual's personal circumstances, background, relationships, and so on and so forth. In relation to the question about Palestine, Israel, self-defense, so it's an excellent question. Shortly after the events of October the 7th, and I think it was pretty predictable what was likely to happen, a small group of us in London, lawyers, British and Jewish, wrote a statement which ran and got a lot of attention in the UK and in other places in the Financial Times newspaper. And we basically made 3 points. One, what happened on the 7th of October is unjustifiable by any circumstance and is a crime under international law, whatever label you give it. Two, Israel, as a state, is entitled within its borders to act in self-defense to prevent such attacks or analogous attacks. I appreciate that's a contested position, but that's my view of the law. But, and this is the crucial point, 3, the right of self-defense is not unlimited. Self-defense describes the right to use military force to protect your borders, to protect your population, to protect your people. The right of self-defense does not tell you what you can do in response. And one of the things you have to do, and that's the reference to the jus in bello, the rules governing methods and means of warfare, is you've got to comply with international humanitarian law. And complying with international humanitarian law means you have to respect certain principles. You have to distinguish between military targets and civilian targets. You have to ensure that the civilian population has what it needs to be able to live, and so on and so forth. You get the point. I've been very clear that Israel has plainly crossed that line. And to say that it has the right of self-defense is not at all to say that the way in which it has exercised that right of self-defense is lawful, because plainly it is not lawful. There is a contest, as coming back to our conversation, as to what label you put on that illegality. Is it a war crime? Is it a crime against humanity? Is it a genocide? Courts and others will express a view in due course as to what label you put on the illegality. I've got no doubt it's illegal, and I've also said to you very clearly that I don't have a hierarchy. Genocide for me is not worse than war crimes or crimes against humanity. I don't care what label you put on it. It's illegal. It's got to stop, and it's got to be held to account. And that issue is right now before the International Criminal Court. It is investigating on both sides what is going on. And what you want to be looking out for is what crimes they investigate for the acts of the 7th of October, what crimes they investigate for Israel's response, and then most significantly, who they target in terms of the investigations, and relatedly, who they then go to the pretrial chamber for authorization to indict. Are they going to go for the leadership on the Hamas side? And if so, who are they going to target? Are they going to go for the leadership on the Israeli side? And if so, who are they going to target? And put yourself in the position right now of the prosecutor of the International Criminal Court.
It's not an enviable position.
Because if he gets this wrong, he's finished. So what this conflict has done has put squarely in the blog whether the International Criminal Court has the gumption to go for the Israeli leadership in terms of decisions that have been taken. That's what you have to look out for.
Okay, well, so on that note then, please join me in thanking Philippe for being here.